You don't own the beach in front of your house, even if the deed says you do. In Florida, in Oregon, in Washington, the moment your feet hit the wet sand, you're standing on state property. And in North Carolina, the dry sand might not be yours either. Gregory and Diane Nies bought their oceanfront retirement home in Emerald Isle in 2001. The sand between their porch and the Atlantic looked like their front yard. Then the town paved a road through it. They sued. They lost. And the legal doctrine that ended their case has been shaping American coastlines since before the United States existed. Gregory and Diane Nies planned to spend their summers on the North Carolina coast. For 3 years, the sand in front of their house was quiet. Then, in 2004, the town of Emerald Isle did something authorized by a state law most beachfront owners never read. It declared the dry sand in front of the Nies home a municipal road. Police vehicles, maintenance trucks, and eventually, the public started driving across what the couple believed was their private property. The Nies family sued for inverse condemnation. That's when a government takes private property without formally seizing it, and the owner demands compensation. They wanted the town to pay for the land it had effectively absorbed. But Emerald Isle had a defense that reached back to Roman law. The town argued the sand had never been private to begin with. It belonged to the public under something called the Public Trust Doctrine. And in North Carolina, a 1998 statute had redrawn the line between private beach and public land in ways most homeowners never noticed. The fight over who owns America's beaches is older than the Constitution. It began in Roman law, where the emperor held the shore in trust for the people. English common law imported the idea. The crown owned the seabed and the tidelands, but fishermen, merchants, and travelers could use them freely. When the American colonies broke away, each new state inherited that sovereign authority over its tidewaters. That ancient rule is the reason a North Carolina judge told the Nies family their property line stopped at the water's edge, and the town's road began. The Supreme Court made this explicit in 1894. In Shively v. Bowlby, the court ruled that the sea and the tidelands belong to the state, in trust for the public. That trust creates a boundary most beachgoers never think about. In Florida, and nearly every other coastal state, the dividing line is the mean high water line. That's the average reach of the highest tides over roughly 19 years. That's longer than most people keep their homes, longer than many marriages, and it moves so slowly that no single storm can shift it. It moves so slowly that no single storm can shift it. Everything below that line, the wet sand and the surf, is state land, held for public use. Everything above it, the dry sand, usually belongs to the private owner. Usually, but North Carolina is not most states. In 1998, the North Carolina General Assembly passed a law that expanded the public trust area to include not just the wet sand, but the dry sand between the ocean and the first line of stable vegetation. The statute, codified in NCGS 77-20 and 146-6, effectively moved the boundary inland. Homeowners who had bought beachfront property under the old understanding suddenly found the state claiming their front yards. Under the Public Trust Doctrine, the state holds coastal land in a kind of permanent guardianship. The public retains rights to fish, navigate, and in many states, to recreate, to swim, boat, and walk the shore. Washington State Supreme Court explicitly extended those rights to swimming and water sports. Texas wrote the right into its constitution with the Open Beaches Amendment, guaranteeing unrestricted public access from the water to the vegetation line. But the doctrine also recognizes something called littoral rights, the privileges that come with owning land next to the sea. A littoral owner has the right to access the water, to preserve their view, and to accretion. That's the gradual buildup of new land from sediment. If the beach grows slowly, inch by inch, that new sand generally becomes part of the private lot. The opposite is avulsion, a sudden, violent change caused by a hurricane or flood. When avulsion strikes, the boundary stays where it was. The new land belongs to the state, not the homeowner. Florida's Supreme Court confirmed this in 2010, ruling in Stop the Beach Renourishment that newly deposited sand from beach nourishment projects did not automatically transfer to adjacent landowners. The mean high water line remained the mean high water line, even when the geography shifted. The court rejected what it called a judicial taking, an argument that changing the legal boundary without compensation violated the Constitution. But the part almost nobody knows is what happened when the Nies family took their case to court. In 2013, Emerald Isle redefined the public trust area along the Nies property to include all the dry sand between the ocean and the dune line. The town then treated that sand as municipal property, complete with vehicle access. The Nies family filed suit in Carteret County, claiming inverse condemnation and demanding just compensation under the Fifth Amendment. They argued that the 1998 statute could not retroactively strip them of property they had bought in 2001. The trial court ruled against them in 2014. The North Carolina Court of Appeals affirmed that decision in November 2015. The appellate court held that the 1998 legislation had legitimately expanded the public trust boundary. The dry sand fell within that statutory public trust area. The Nies family never possessed the exclusive ownership required for a takings claim. The town was not seizing private land. It was managing public land the state had always held in trust. The court emphasized that legislatures have the authority to define the geographic scope of the public trust, provided they do not eliminate the trust itself. The Nies family appealed to the North Carolina Supreme Court. In December 2016, the court declined to hear the case, letting the appellate ruling stand. The Pacific Legal Foundation, a property rights organization, then petitioned the United States Supreme Court. In 2017, the court denied certiorari, refusing to review the matter. The Nies family received no compensation. The road remained. And in North Carolina, the statutory public trust now covers not just the wet sand you expect, but the dry sand where you spread your towel. North Carolina was not the only place where private sand met public rights. In New Jersey, the Atlantis Beach Club in Cape May tried a different approach. The club charged high fees for access to its 342-foot stretch of dry sand. Neighbors sued under New Jersey's Public Trust Doctrine. In 2005, the New Jersey Supreme Court ruled in Raleigh Avenue Beach Association v. Atlantic Beach Club that the club had to open its sand to the public. The court applied a test from Matthews versus Bayhead Improvement Association, requiring reasonable access to the tidelands. Because the public could not reach the water without crossing the dry sand itself became part of the trust. The club could charge fees, but only after the state reviewed them, and the public retained the right to walk the shore. The results vary dramatically by state. In Maine and Massachusetts, private owners often hold title down to the low water mark, and the public retains only fishing, fouling, and navigation rights. Massachusetts legislators have spent years trying to expand recreational access, but as of 2026, the intertidal zone remains largely private. In Oregon and Hawaii, the public trust reaches the vegetation line, or the highest wash of the waves. Texas goes further. Its Open Beaches Amendment, written into the state constitution, guarantees free and unrestricted access from the water to the vegetation line. When SpaceX closed Boca Chica Beach for rocket launches in 2025, Texas courts began examining whether those closures violated that constitutional guarantee. Even within the same doctrine, the ground beneath your feet changes the moment you cross a state line. Courts have spent centuries drawing legal boundaries in sand that washes away twice a day. American property law at its most literal. The Nies family lost their case. They lost their appeal. They lost their shot at the United States Supreme Court, and they never got a check. But the legal story did not end with their defeat. It ended with a boundary line. North Carolina's 1998 statute drew that line not at the water's edge, but at the dune. The courts agreed the legislature had the power to draw it there. The public trust, they held, is not a fixed monument. It is a living legal framework that states can expand, contract, and redefine within constitutional limits. The Nies family bought their home when the line sat closer to the sea. By the time they sued, the state had moved it behind their porch. The Fifth Amendment promises just compensation when the government takes private property for public use. The Nies family argued that moving the boundary was exactly such a taking. The courts disagreed. They characterized the dry sand as trust land the state had always held, not private land the state had seized. No compensation was due because, in the eyes of the law, the Nies family never truly owned the sand the town turned into a road. That reasoning echoes across American coastlines. In Florida, beachfront owners watched new sand from renourishment projects become state property. In Texas, homeowners near SpaceX launches confront a constitutional right of public access that predates their deeds. In New Jersey, private clubs must share their sand. The doctrine does not care what the realtor promised. It cares where the tide has historically reached, what the legislature has written, and which state you stand in. What does this mean if you're standing on a beach this summer? First, the wet sand is almost certainly public. In nearly every coastal state, the mean high water line is the border, and everything seaward of it belongs to the state. You have the right to walk it, fish from it, and sit on it. Second, the dry sand is a patchwork. In Texas, Oregon, and Hawaii, you likely have a right to cross it. In Maine and Massachusetts, you may be trespassing the moment you step above the high tide line, unless you are fishing or navigating. In North Carolina and New Jersey, the public trust has swallowed portions of the dry sand through statute and court ruling. If you own beachfront property, your deed is not the final word. State legislatures can redraw the public trust boundary. They can open your front yard to vehicles, as Emerald Isle did. They can require you to maintain public access across your lot. And if a storm rebuilds your beach overnight, the new sand may belong to the state, not to you. The mean high water line does not move with the sand. It moves with the tide averages recorded over nearly 2 decades. The doctrine also cuts the other way. If you have used a stretch of private beach openly and continuously for decades, you may have created a customary use right. Florida courts have recognized such rights where the public can prove long, uninterrupted, reasonable use. The beach remembers who walked it, even when the deed says otherwise. The next time you spread a towel on sand you assume is public, look behind you. The dune might mark the edge of someone's property, or it might mark the edge of a legal doctrine older than the nation itself. If you have ever wondered why some beaches have no fences while others charge admission, you now know the answer. It is not the market. It is the mean high water line, the state legislature, and a 2,000-year-old idea that the sea belongs to everyone. Subscribe if you want to know what the law says before it costs you. Tomorrow, we're looking at a 2026 ruling that just changed when police can seize your car during a traffic stop, and why the Fourth Amendment might not protect your glove compartment the way you think. You'll want to see that one.